SJC-12310, Commonwealth v. Cara L. Rintala.
Okay, Attorney Wood, we're ready for you.
Thank you. May it please the court, Chauncey Wood for Cara Rintala. The opinions of the Commonwealth's so-called paint expert, David Giulianelli, that the paint at the crime scene was intentionally poured and poured within 30 minutes of the first responders' arrival were grossly unreliable and therefore never should have been admitted at Cara Rintala's third trial.
Counsel, I know that you've got a number of issues, and this is going to be the big one because the amicus also chimed in on these, but can we go through what happened here and look at this and say, Judge Rupp took the matter under advisement after having oral argument. This isn't, I know that was a 16L letter that was filed that tried to say that this set of facts was kind of analogous to our recently issued Hines decision, but this particular gentleman had incredible qualification in the sense that had an undergraduate degree in hard science, had spent 20 years indeed had worked on the, if my memory is correct of the record, this particular paint. So what is it about what is it that's unreliable here? Is it just that you don't like the conclusions, or that it's really unreliable because it was based on someone who had been in this industry, who knew a lot more about paint than any of us do, that talked about some of the things that he did to kind of replicate what was known and came to a conclusion? What's unreliable about that?
So first of all, there's so much in that question. The most important thing, well, the place to start is you've characterized this as incredible experience. I vigorously oppose that. The amici go into this, we all go into this in great detail. His incredible experience is as a guy building paints for architectural applications.
Sure.
He himself admitted quite emphatically this was a new area of inquiry for him. What we're talking about here is the forensic application, the design of experiments to determine forensic applications of paint. He had no experience, no relevant experience in that area. Dr. Lugalam goes through this in great detail. What we needed was a scientist with a background in designing experiments. He had no relevant experience designing experiments. To suggest that he had incredible experience in this area is most respectfully not on point.
Well, that's not what I was alluding to. I was alluding to paint and paint drying, not about whether or not he has an incredible experience in designing experiments to figure out how often and how fast paint dries. He knows about paint. And and I think both sides distilled this too, that the relevance of this evidence was with respect to how fast this paint dried.
Right, so well, there's two elements. First of all, there's two elements. How fast the paint dried and whether it was intentionally poured or accidentally spilled. Now, on the drying time, the fundamental problem was he had no reliable methodology. We need to tie this to the doctrine. I'm not painting, excuse the pun, on a blank canvas. This requires a reliable methodology. He had no reliable methodology. If I go back to Hines, this court's recent comment on the bedrock beginning principle, this court stated quite clearly and efficiently, experts in hard sciences primarily base their findings on repeatable experiments conducted under controlled conditions. The fact that he had a long history working with paint doesn't allow him to throw the Daubert-Lanigan standard out the window. The question is still before us. Did he design repeatable experiments conducted under controlled conditions? The short answer is no. He did not control for individual environmental variables, paint thickness, homogeneity, temperature, humidity, porosity of the concrete and human skin, rigidity of the concrete substrate, airflow, the effect of disturbing the paint. Despite all of this, the prosecutor erroneously claimed in closing argument all variables were taken into account. Absolutely untrue. And again, his experience working with paint doesn't answer any of this.
Didn't he talk about that he adjusted for various variables. He used the humidity that was on the humidifier, and I understand that there's some argument that they're not reliable and that they can vary, and that so it's not really telling you anything. But there were a variety of different variables that he accounted for, didn't he?
So he conducted, I don't want to go down the rabbit hole. The short answer is no. The slightly longer answer is he conducted 6 individual trials, maybe 7, I can't remember, 6 trials, I think. Each of them was different. Another hallmark of science is you must repeat your experiments. In each of his experiments, they were different. He added a different variable. Now, that's one problem, but also what Your Honor is alluding to is partially true. In 4 of the 6 trials, he conducted them in an atmospheric chamber. And in that chamber, he was able to replicate roughly the humidity and temperature of the environment in the basement. But there's details that I don't want to waste time on. We're not sure that that was even accurate. In the first 2, he did not control for that. But in the last 4, a different problem, he added a different variable each time. And in all 6, he didn't repeat his experiment. This is basic high school science. He did not follow the scientific method in the least. And the result, as Your Honor briefly alluded to, is the results. Are they useful? No, they're not useful to address the question before us, drying time. And that's the first question. The second question he was asked to address is the intentional or accidental spilling, intent of the party. And at least with regard to drying time, he tried to develop a methodology. And we say it wasn't even close to reliable. With regard to the intentional pouring of the paint, that was based on pure, naked speculation, nothing more. He admitted that much on cross-examination. And this is a point I actually want to speak to the court about stepping back. When we talk about the standard of review and what evidence this court should consider, this is a really important point, and I don't think we addressed it fully in the briefing. Normally, you give respect to the trial court and you require the parties to present evidence to the trial court, and you only consider the abuse of discretion. So the question is abuse of discretion. And in analyzing whether the judge abused her discretion, we say what evidence was before her. In this situation, there's a different rule. Commonwealth v. Camblin, this court has articulated it. You are not only permitted, but you yourselves have said, we will consider all the reliable evidence out there to make sure that ultimately this opinion was reliable, because we only allow reliable evidence to get to the jury. I'm not talking about credibility, that's for the jury. But here, it's important to understand there are 2 sources of evidence, really 3. One, the cross-examination by Attorney Hoos. There was no evidentiary hearing, no crucial gatekeeper function here at an evidentiary hearing. Attorney Hoos, most importantly, got Mr. Giulianelli to concede every single point that he relied on for his speculation that the paint was intentionally poured was indeed pure speculation. He admitted it was speculation. You can consider that because that never was before the trial judge in her gatekeeper and in her preliminary judgment. The second point is Dr. Lugalum's affidavit. Dr. Lugalum, as we indicated in our reply brief most specifically, made points that Mr. Hoos did not make on cross-examination. Your honors are explicitly authorized by your own case law, Camblin, to consider Dr. Lugalum's opinion. And then finally, there was a crucial point by one of the Commonwealth's own experts, Dr. Andrews, because the question on, I'm sorry, I'm jumping to a different opinion, so I'll stop there. But this court, on the question of whether Mr. Giulianelli's opinions were reliable, is permitted to consider the cross-examination of Mr. Hoos, the concessions by Mr. Giulianelli that his opinions were pure speculation, and the opinions of Dr. Lugalum illustrating how, in every way possible, Mr. Giulianelli's opinions were not based on reliable methodology and were nothing more than naked speculation.
Could I go to Dr. Lugalum's affidavit for a moment on your last point?
Yes.
So this raises a little bit of a complicated issue, because that affidavit wasn't available to Judge Root. I assume it was available, it was available to the trial judge who heard the motion for new trial, right?
I think you mean post the evidentiary hearing after trial, Judge
So
McQueen.
Judge Roop retires, and
Yes.
then there is not an evidentiary hearing after trial. There is no evidentiary hearing.
Right.
But at the motion for new trial,
Yes,
that affidavit submitted.
yes, Judge McQueen had that affidavit,
Okay.
yes.
So it seems to me that we have to sort of separate something you just said. I don't think when we're looking at whether or not Judge Roop abused her discretion on the gatekeeper issue, something that she didn't see. But I do think that that affidavit can be considered by the motion for new trial judge in deciding whether in fact there really wasn't gatekeeper reliability.
I think there's no meaningful difference between our positions. I wouldn't blame Judge Rupp. As a practical matter, you don't blame a judge for not considering something that wasn't before her. I think we agree to that much. And then Judge McQueen had the affidavit of Dr. Lugalum, and so that is relevant information for deciding after the fact whether Judge Roop abused her discretion as a gatekeeper without any blame to Judge Roop because she didn't have it. I think we're saying the same thing. Okay, so if I've answered your question, that's my view. Now, on prejudice, this is crucial because I have to prove prejudice. There are 4 points here that are crucial to establish why there's no doubt that this was prejudicial. And first of all, it was, as the standard of review, abuse of discretion. If it was erroneously admitted, if it was unreliable and therefore inadmissible, then because the defense preserved the issue quite emphatically, the issue is harmless error. Can you say clearly this didn't matter? 4 things. First, 2 trials before this, before we ever heard from Mr. Giulianelli, both resulting in hung juries. The only new material evidence was Mr. Giulianelli's opinion, his 2 opinions. Second, the prosecutor relied heavily on this opinion in closing argument, asserting that they demonstrated consciousness of guilt. Third, the judge gave a sua sponte consciousness of guilt instruction for the first time at this 3rd trial, focusing the jury's attention on the evidence of consciousness of guilt. Mr. Hoos did not expect the instruction. We focused on that in our appeal, but it focused the jury's attention on evidence of consciousness of guilt, the weakest part of the Commonwealth's case. And finally, 4th, as if that weren't enough, the jurors gave a post-trial interview on Dateline and stated that the paint evidence was important to their verdict. So there can be no doubt that this opinion testimony that the paint dried the paint was poured intentionally within 30 minutes of the first responders arriving was material to the jury's verdict. I want to...
Do you want to address stain on the paint?
Yes.
Because quite frankly, that's I think your best argument. The ineffective assistance of counsel issue.
So I think this is really interesting, and we struggled, obviously, and I think doctrinally everybody is struggling with this. This court's line of cases, well, first of all, 33E review and Wright, doctrinally, the court is very clear and right. If there's an error by any party, the judge, the prosecutor, defense counsel, that has an effect on the jury, it creates a substantial likelihood of a miscarriage of justice, we're going to reverse. In a first-degree murder case, we're not going to get too caught up in figuring out which doctrinal bucket this goes into. That's the first point. And this court has, in concrete circumstances, extended that doctrine in a lot of different situations. So that's relevant in the background. But another point that's specific to this case, which I think is really intellectually interesting, is while it's true that defense counsel made some missteps, excellent defense lawyer, one of the best in Massachusetts. I don't want to bring an ineffective assistance claim. I have to concede, of course, Mr. Hoos is an excellent lawyer. But he didn't request an evidentiary hearing on this brand new novel opinion. That's probably a mistake. He also didn't have an expert. It was hard to find the right kind of expert. It took us a while to find an academic with a specialization in material science and specifically the effects of nature on building materials and the proper background, experimentation, not a guy who builds paints, a different kind of experience. So it's hard to find that. So I don't blame Mr. Hoos for having a hard time. But the really interesting point comes back to Camblin, Commonwealth v. Camblin. This court is mostly concerned with reliability. Reliability is the lodestar for admissibility. And this court, therefore, takes an expansive view of the record we can consider. And that's against the backdrop of 33E, which says we have an expansive view of the cause of the error. We're really just concerned, was there an error? So we can look at everything and decide, ultimately, in a post hoc sort of way, was the judge's decision an abuse of discretion? And I don't think it matters that the information was, for example, Dr. Lugalum's affidavit was produced after the fact and that Mr. Hoos failed to find an appropriate expert. What really matters is whether Dr. Lugalum's affidavit and Mr. Hoos's very effective cross-examination and all the totality of the circumstances demonstrates that this opinion was unreliable.
Can I ask, just to cut you off for a second, I know you're on a flow, but back to Justice George's original question, this guy knows a lot about paint. He may have gone way beyond what he can talk about, but if he had been more limited in what he testified to, our paint dries within 30 minutes normally when it's applied. I don't know, the effects of, we don't pour paint on people, we pour paint on walls. But I take it that he could testify as an expert in a limited way here. Is that correct?
You're asking for a hypothetical. It is in
Well,
this case.
I've got a follow-up question. Why don't you start with that one?
Oh, I'm sorry. Okay, so he knows a lot about paint.
He knows a lot
I don't know
about
what
paint.
that
He knows a
means.
lot about this paint. He knows how long it takes to dry. He knows how it changes color. I'm not saying he can do all the stuff he did here, but he can testify to that, couldn't he? Judge Rupp would certainly not have been an error if she kept him in that box, right?
So the Hines decision, my first reaction is the Hines
I
decision.
love an answer just to the question.
No, it's not a relevant fact. So no, you can't give an opinion that something's irrelevant.
This
to a
guy
point that's irrelevant.
can't testify on how long paint dries and how it changes color when he knows this paint probably better than any human on earth?
Right, so this paint, meaning this paint is the forensic application of this paint in a thickness
All right,
that is
so you're not going to
it's
answer my
designed
question,
for.
but I'll go to the next question. This lawyer is terrific at basically tearing apart the stuff that he doesn't really know. So is the error here harmless? Because, again, I disagree with you and think this guy could have given some testimony, but he went well beyond what he knows and what he could testify to, but the lawyer tore him up well.
Yes, so harmless. Sorry, go ahead.
And the lawyer had an expert, but he was the brother-in-law or the father-in-law, so he doesn't want to use him, but it's hard to say that, because I'm not sure he wanted all that evidence about drying of paint, because it may have hurt his client, right? So he doesn't bring in an expert, but again, it's tough on ineffective assistance when you've got such a good lawyer who did such a good job on cross-examination. But I do see the point that this guy's out there talking about stuff he doesn't know. Mm-hmm.
So the shortest answer is, and I've covered this, harmless error. How could this be harmless error? To all of us reading that cross-examination, we thought this should be in a CLE. This was a spectacular cross-examination. The problem with that, she was convicted. She was convicted of first-degree murder. So how do we know that this made a difference despite this spectacular cross-examination? Because, first of all, there were 2 hung juries before. You add the paint evidence, and you get a conviction. There's doctrine, Uber v. Guarino.
I haven't read the trial transcripts of the earlier ones or this one yet. Was there testimony about the paint in the prior trial? And nothing about how long it takes to dry, nothing about any of that stuff?
No, sir.
Okay.
So the second point, the prosecutor relied explicitly on this point as consciousness of guilt in the third trial, on Mr. Giulianelli. Again, notwithstanding that we might say this jury shouldn't rely on that. That is not a good argument. The fact is, the prosecutor chose to rely on it, and the jury convicted. The third point, the judge gave a sua sponte instruction that focuses the jury on this. And fourth, post-trial interviews, the jurors say the paint evidence made a difference. Again, we can sit here and say that was great work, and we can say he shouldn't be guilty of ineffective assistance. The question before the court, and this is why I went into this long apparent diversion, is that's not the question that we need to focus on. Was this evidence reliable? And if it was not reliable, the judge, as gatekeeper, did she abuse her discretion in letting it go before the jury? There are many...
Mr. Wood,
Yeah.
I don't want you to repeat that because
Yeah.
you're running out of time.
Yes.
So, you know, we can dig into the gatekeeper reliability issue, but I think Justice Gaffer was getting at the issue of whether there should be a remand because we need a factual predicate to deal with manifestly unreasonable and whether or not, you know, we're not applying Safarian, we're applying 33A. And so you're saying, and it's, I think, a really good point, this is very powerful evidence. My gosh, if the jury thinks right before the police came, she poured paint all over her, you know, good luck with getting her not guilty. So the point's well taken. But the question is, in this situation, not only do we need the second prong, not in a factual vacuum, but, you know, the first prong, and it doesn't have to be reasonably below, it just has to be whether or not it would have been error. It's a lower standard on the first prong. There's an issue here. I haven't really gotten a chance to digest the transcript either, but you can tell we did a great job on cross. But isn't there a real issue with it's easy to quarterback on Monday morning, hindsight's perfect science and all of that, but if this evidence was so important, is there an evidentiary hearing on remand that might need to be taken here if in fact there wasn't a gatekeeper reliability issue?
So I think the short answer is we think that the record establishes Dr. Lugalem's opinion, and the undisputed record establishes the narrowest holding. I think that on the second part of his opinion, that the paint was intentionally spilled, he admits himself on cross-examination that was pure speculation. The case law is clear. An opinion, expert opinion based on pure speculation is inadmissible. So I think that narrow point renders the judge's decision an abuse of discretion, and we don't need an evidentiary hearing to establish that. And moreover, if it's not intentionally poured, how long it took to dry becomes irrelevant because it could have been.
I'm not asking about gatekeeper reliability.
Right.
Just so
Right.
I think you know where I'm going.
Yeah, so
Just to
ineffective.
save time, I'm not asking about gatekeeper reliability.
Okay.
If you win on that, you don't have to worry about
Okay.
my question.
So on ineffective assistance, if we're analyzing this as ineffective assistance under 33E, it's true that no judge has had a chance to, the Commonwealth has not had a chance to cross-examine Dr. Lugalem. So as an alternative, we would recognize, if we're looking at this as 33E for ineffective assistance, that a remand for, we would accept a remand in the alternative to a trial judge. It can't be Judge Mulqueen because she's recused herself, but to another judge, then we would agree that that is appropriate. And furthermore, to, I guess, explore Attorney Hoose's decisions and whether they were reasonable tactical decisions. I think that's all fair play in an evidentiary hearing, and that is an alternative request that we made in our briefing for an evidentiary hearing,
Okay.
if that answers that.
Thank you very much.
Thank you.
Okay, Attorney Gagne.
Thank you.
Good morning, Your Honors. May it please the Court. Stephen Gagne. I'm the First Assistant District Attorney for the Northwestern District. I was trial counsel in this case. And with me virtually today is Deputy District Attorney Jennifer Sewell, who was co-counsel in this case. Your Honors, the Commonwealth asks this Court to affirm the defendant's 2016 conviction for murdering her wife inside their home in Granby, Massachusetts. As you know, this case has a long procedural history. with 2 hung juries and an unsuccessful appeal by the defendant to this court in an effort to prevent there from being a 3rd trial. All throughout that time, Judge Mary Lou Roop, who had served on the Superior Court since 1992, retained jurisdiction over this case and became intimately familiar with it. On appeal, the defendant argues that Judge Roop abused her broad discretion in a number of pretrial and mid-trial rulings. And while this court's review under abuse of discretion is not perfunctory, it also affords great deference to trial judges. And in this case, Judge Roop's discretionary rulings, particularly her decision to admit expert testimony in this case, cannot be said to be so far outside the realm of reasonable alternatives or that it amounted to a clear error of judgment. Now, with respect to the paint evidence, the Commonwealth's burden at the pretrial Daubert-Lanigan stage on the motion in limine was to establish to a preponderance of the evidence, more likely than not, that this evidence was sufficiently reliable to at least reach the jury.
Well,
And-
counsel, if we could just dive right into it. So Attorney Wood brings up 2 different aspects of the paint evidence, not only of the drying, but of also to the issue of whether it was intentionally poured. Do you concede at least that second part that he was not qualified to opine as to whether it was intentionally poured or not?
I would concede that it was not as firmly rooted in his testing and his experience as perhaps the drying time. I do not think it was beyond the realm of his expertise, and I would direct Your Honor's attention to the defendant's record appendix at pages 201 to 204, because that is where Mr. Gianelli laid out 6 different points from which he concluded that this was an intentional pour as opposed to a spill or a drop. It was not, as Attorney Wood argues, mere speculation, and Mr. Gianelli never said on cross-examination that this was just his own wild speculation. He pointed to the unique flow patterns that the dye in this paint left, which would not be there if it was dropped or spilled. So it was rooted in his experience, and it was well laid out and documented in the discovery that Judge Roop had when she allowed this in. Now, when it comes to the drying time experiments, first of all, it can't be overstated how experienced and knowledgeable Mr. Gianelli was, not just within the paint field, not just as 20 years of a chemist. He literally designed this paint. This was a unique type of paint with this added dye for ease of application by the customer. He thoroughly documented his work in this case. And it's worth noting, as he testified, when he was first contacted by the Commonwealth, the working theory was the change in color may tell us something here about the time. Based on some preliminary testing he did, he actually said the color change really doesn't apply when we're dealing with poured paint. But what is interesting is the visual changes in this paint as it dries over time. Now, he thoroughly documented his work, all of which Judge Roop had when she ruled on this. 369 photos, 252 pages of notes and reports, and a 14-page report that he authored in May of 2016 prior to trial.
Yeah, I'm not, you've got 2 evidence professors on the panel, and I'm not one of them. But I find that this seems junky in terms of science. So tell me, is this a repeatable experiment? Is somebody capable of doing what this guy did again and verifying that this was correct? Because this seems like, playing in your garage with paint rather than, I get that he can describe his own paint when they put it on walls and, how it, it was a good paint, but this is like, this seems like we're off in a totally different direction here. So tell me why this isn't junk science.
Yes, Your Honor. Well, this was admittedly a unique fact pattern and a unique crime scene at which paint was poured over a body. However, you mentioned repeatable experiments, and Attorney Wood says also controlled conditions. That is exactly precisely what Mr. Gianelli did here. He conducted 6 rounds of testing. He thoroughly, photographically documented. In the supplemental record appendix, you can see almost minute by minute, the temperature down to the 10th of a degree, the relative humidity. So not only did he repeat his observations multiple times, but they were controlled conditions. These were environmental chambers in which he was conducting this analysis. So this is the farthest.
And the expert they hire to pick this apart, what does he say about all of that?
Essentially, it's just an amplification of what Dr. Gregory Otto put in his affidavit, which Judge Roop had, which was, there are some variables here that perhaps you can't control for. And Judge Roop specifically addressed that head on in her decision. She said, I've read the affidavit from the defense expert. Admittedly, perhaps this cannot be perfectly replicated. However, it's replicated closely enough that it meets a reliability threshold and the jury can hear this. And Judge Roop explicitly acknowledged that even once she lets this in as gatekeeper, that's not the final word on reliability. And Justice Kafker, as you said, I think you said, beat up the defense, the witness, or roughed him up, so to speak. I admit this was a pretty effective cross-examination. I was squirming as I was watching it happen first real hand, but that is exactly what this court has said, what Daubert in the United States Supreme Court said, that if you have a case, and I'm not saying that this was shaky evidence, but in cases where there is shaky but admissible evidence, if you meet that preponderance standard, which is admittedly low, it's then within the square realm of trial counsel and the jury to decide how much weight to give this, if any. And on that point,
Right, but you know, again, I'll defer to my colleagues who teach evidence, but we have a gatekeeper function so that the thing has got to be reasonably reliable. I don't know exactly the standard, sufficiently reliable, and it just seems like we're awfully close to the edge here on that, but.
Well, Your Honor, I would point, and I think I made this point more thoroughly last Friday, and with the court's leave to accept this filing, I did file a response to the amici filings in this case, in which I discussed how in this realm, this court has acknowledged that not all areas of expert testimony are equally far outside the ken of the jury. And in this case, ultimately, what we are talking about here is the fairly common sense notion that paint dries. Mr. Gianelli didn't just come in from his factory in Strongsville, Ohio and say, oh, I know all about paint, and let me tell you, it dries. That would be a situation analogous, I believe, to the Frangetti case, which this court decided a couple of years ago, where an accident reconstructionist looked at a scuff mark in the road and essentially said, oh, I know scuff marks. That's a scuff mark from a sneaker. I've seen it before, trust me. No foundation, no testing, no anything. In this case, Mr. Gianelli didn't do that. He did what he does in his industry, using environmental chambers, repeated experiments, repeatable experiments under controlled conditions, and he documented it all through photography, and some of that photography was introduced to the jury at trial, showing a fresh pour and a pour several hours later. And they could see with their own eyes what their common sense would have otherwise told them. Paint dries over time. So this was something where an expert was simply helping the jury to understand better evidence that was already in the case. And I'd suggest that distinguishes this case perhaps from fingerprint or DNA cases, where if that expert doesn't come in and tell the jury about DNA matches or fingerprint matches, the jury is not hearing about that at all. Here, the paint evidence was in the case. It's dry.
I'm going to ask you to move away from dry and move over to pour. Because this, I know Mr. Wood disagrees, but this guy's in a way like the expert in Cuomo Tile versus Carmichael, he was the tire guy. Mm-hmm. This guy's not just the paint guy, but he's the paint guy about this paint. But the fact that he's the paint guy and he's qualified doesn't mean that his methodology as to pouring satisfies Tubbs Lanigan. So what he's doing is he's saying, he's applying his personal observation and experience. And he's saying that this was poured. Just on that issue, I know you've referred us to page 201 through 204 of the defendant's record appendix, but what's the methodology that he uses to say this was poured, other than I'm a paint guy and I'm a really good paint guy, I use this paint and I think it poured?
He was firmly rooting his opinion in the trial evidence, in the crime scene photographs, in his trained...
He absolutely had a basis for his, he's qualified, and he's got a basis for the opinion. I'm giving you both of those. Whether we end up that way when we dive in, I'm giving you that he's qualified. I'm giving you that there's a basis for the opinion.
Okay.
What's the methodology that he uses to say this was poured, so that we can understand that methodology for gatekeeper reliability?
Well, admittedly, he did not conduct drop or spill testing and document it as he did with the drying time. However, this court has recognized that experts, through their training and experience, they can look at something and they can discern things that the ordinary juror necessarily wouldn't.
Too.
Pardon me?
I'll give you that too. And we said it in recanting. Observation and personal experience can be enough. But it can't just be like in Cuomo Tire, where the expert says, I touched it, I felt it, and it was defective design, not misuse. What is the methodology that he's applying to say it was poor?
And counsel may follow up on that, because that's not just an esoteric question, because there are instances in the record that confused me with that, and I'll give you why. In one sense, and I don't know, and I can't remember exactly where, but he talked about how the absence of splatter was one factor, or something that was considered with respect to whether it was poured or knocked over, right?
Yes.
But then he also talked about how, I believe this was ceiling paint, right?
Yes.
And that it was designed to not splatter, right? Because forget about the composition of it. He talked about the four things that go in it. But part of it was, because it was ceiling paint, it was formulated in a way to reduce splatter.
Yes, Your Honor, that testimony was specifically in reference to when a customer applies this paint as designed
Sure.
with a roller at a thin film, it will not splatter.
Right.
I mean, clearly, if customers are rolling it on the wall and it's spraying back on them, it wouldn't sell. But what he was saying is that if this paint were dropped from some distance, one would expect, as almost with any fluid, that you would see. I mean, I know that in my kitchen, if my daughter drops a little cup of yogurt, it ends up on every surface within 20 feet. So he's simply saying here, again, a fairly common sense example, that there would be spatter. It would not be a flow pattern, and you wouldn't see that dye pattern inside the bucket. Particularly, you wouldn't see the bucket lying on top of the lid. Now, maybe that's something that a juror could see with their own common sense, but he was bringing a gloss to this. He was bringing a lens and pointing out things to the jury that perhaps the ordinary layperson would not appreciate.
Perhaps, but he also backed off of that, right? That the issue about the canister or the paint being on top of the lid, right? And that having anything to do with being able to glean whether it was kicked over or that it was poured.
You know, if anything, that's one of the beautiful points I think about Mr. Gianelli's testimony, is that he freely acknowledged everything he didn't know and everything that was based on perhaps partial assumption. In fact, his testing, he conducted his testing of the drying time in such a broad range of temperatures and humidities that he said, although it's highly unlikely, I admit this paint could have been poured 4 hours before anybody got there. So he didn't come in and say, this is bedrock science and I know better than anybody else in the world, trust me. He acknowledged what he didn't know, defense counsel skillfully hammered home every assumption that his testimony may have been based upon at certain points. I will admit that of the two opinions he gave, the intentional pouring was less firmly rooted than the drying time. But I would argue that that opinion of the two was the less beneficial to the Commonwealth. And the reason I say that is because regardless of whether this paint was poured or spilled, what mattered was the time differential between a cold, rigidly stiff body whose arms are literally suspended off the ground in full rigor mortis, which takes 6 to 8 hours to form, versus what was uniformly described by first responders as wet, fresh, shiny paint. Those two timelines do not match up. So the significance of the drying or lack thereof was really the linchpin of Mr. Gianelli's testimony. And if he perhaps went a little farther out on the limb than his weight would support with the pouring, that would not be sufficient grounds to overturn the defendant's conviction. My brother mentions prejudice, and he says that this testimony was what tipped the scales into Cara Rintala's conviction. I strongly disagree. He mentions the fact that there were 2 mistrials before this one. That's confusing correlation with causation. In this case, the Commonwealth's time of death evidence was much stronger than it was in the first 2 cases because Dr. Thomas Andrew, completely unconnected witness from New Hampshire, 25 years as the chief medical examiner, he's asked to formulate an opinion as to time of death, and he has no idea what time Cara Rintala left the house that day. He was specifically kept from that evidence to avoid any bias one way or the other. And he said explicitly, 1 o'clock is my opinion, give or take. 3 o'clock isn't even on the table. Secondly, the Commonwealth's strategy in its case in chief in this case was very different than the first 2 trials, where this time, because the defense's theory here was so strongly rooted in rush to judgment, botched investigation, insufficient investigation, the Commonwealth did not call its lead investigator, Trooper Megarian, and basically we elected to say, if the defense wants to build that defense, you call him, and they did. And I think that changed.
I'm not so sure that when we're going to look at prejudice, it benefits either of you that as far as applying the doctrine. Well, oh, there was a mistrial this time and the time before. But to me, I mentioned this to before as well. To me, if she poured the paint, that's brutal consciousness of guilt evidence. And I imagine maybe Judge Roop gave that instruction because you had such consciousness of guilt evidence, and the construction also benefits the defendant.
Well,
But I'm sorry, go ahead, and then I'm
just
gonna
briefly,
ask
I
you
just
about
want to highlight your use of the term she. Mr. Gianelli could not obviously say who poured it. He said it was most likely poured roughly a half an hour before first responders got home. Whether or not Cara Rintala was even home at that time is debatable because there was evidence she was in Chicopee buying mac and cheese at 6:58 p.m. and first responders are called around 7:15. So he couldn't point the finger to anybody in particular. And even if the paint was poured 30 minutes, 60 minutes, 4 hours before people got there, still, that could have been the person somebody else who killed Anne Marie Cochran at an earlier time. So I do quibble with your use of the term she. That's taking his testimony even farther than he did.
Let me ask you why we don't need a remand here on the issue of whether it was an error for defense counsel. It doesn't have to be Strickland, that there was an error of defense counsel not hiring an expert, considering how important this testimony was. I mean, the paint evidence is a huge issue in this case.
Yes, Your Honor. Respectfully, I do not believe a remand would really shed much new light on this issue because it won't change the fact that trial counsel consulted with 2 different experts prior to trial. There was Dr. Otto Gregory, whose affidavit he submitted to Judge Roop, and then Dr. Robert Iezzi, who he also consulted with but ultimately chose not to use. If I may finish my answer, I see my time has expired, Your Honor.
You have to ask the chief.
Oh, yeah,
Sorry.
absolutely. Go ahead.
Yes, so both before and at trial counsel had consulted with 2 experts, and he specifically relied upon the assistance of Dr. Gregory in crafting that damaging cross-examination of Mr. Gianelli. When Judge Roop denied the motion to eliminate, she was privy to these many challenges and critiques. And when Judge Mulqueen denied the motion for new trial, she was privy not only to the record that Judge Roop had, but the enhanced and amplified affidavit by Dr. Loughlin. And she too found that there was no ineffective assistance here and no grounds for a new trial. And for what it's worth, and I would suggest it's worth something, when Judge Carey, another esteemed and experienced member of the Superior Court, denied the motion for stay, he found that this issue lacked heft. So obviously this court is not bound by the decisions of lower court judges, but I'd suggest it's worth something that 3 experienced, very capable Superior Court judges here have looked at this evidence and said it was not an abuse of discretion to admit it, it was not ineffective assistance of what we both agree on here, perhaps the only thing, one of the best trial attorneys in Massachusetts over the past 3 decades. So having said that, if the court is sufficiently concerned about this issue, obviously we would prefer a remand to a reversal, because I would like to see how these doctors hold up, how these professors hold up under cross-examination. If I get the chance to do to them what Attorney Hoos did to Mr. Gianelli, perhaps ultimately we'll be back before this court, because a new Superior Court judge, the 4th one now to look at this case, is going to decide in his or her opinion that this was or wasn't ineffective, or this was or wasn't reliable. We'll be back here arguing abuse of discretion once again, albeit on a perhaps more fully developed record. So I really don't think that's going to change the ultimate analysis that we're asking this court to perform at this stage.
Okay.
For those reasons, Your Honor, I would ask Your Honors to affirm Cara Rintala's murder conviction.
Thank you very much, counsel.
Thank you.
Period. All persons having anything further to do before the Honorable Justices of the Supreme Judicial Court, now sitting at Boston, within and for the Commonwealth, at present apart, the sitting of this court is now adjourned. Please remain standing as the justice exits. Thank you.